I'm really excited about tonight's call. We're going to talk about the ultimate asset protection structure. So, as many of you know, I am not an attorney. I'm not a CPA, although I work with the best attorneys and CPAs in the country, and I have many that work with me full time for the structures we have for our students. I am, however, a hedge fund manager. I've had the hedge fund Mixif.com, as you see it, Metawar International Group Secured Income Fund. I've had that since 2009. We invest the investors' money in real estate, mainly in the San Francisco Bay Area. We've done very well. We have people making 8% compounded, which is a wonderful way to invest your money safely. I am an educator as well. I have my training company since actually 1999 now. It's been almost 15 years. CMREI.com, Sharif Metawar Real Estate Investing. And I am also an author. I am so honored that I've actually wrote a book and published it early last year. It was called The Blue Ocean Opportunities in Commercial Real Estate. It was a bestseller on Amazon. We've had write-ups in Forbes, mentioned in CBS News, Fox News. It's about commercial real estate and how I focus on single-tenant retail and create wealth where nobody else is looking. We've trained a lot of people on this, and we continue to do so. Also, I'm happy to tell you that the book I co-wrote with Mr. Steve Forbes is now out, and it was published first quarter of 2014. He is in chapter 1, I'm chapter 2, and there are some other wealth advisors in there. Phenomenal book. I wrote in it the 12 steps to be financially wealthy. Actually, a couple of hours ago, I just finished an interview with a radio station. I've been interviewed practically every week since the book came out about the 12 steps, and each radio station asked me to focus on a different area. So let's get busy and talk about financial peace of mind. It is based on your assets earning power. So what do you have to have? 3 things. You got to get reliable and growing income, and that, of course, comes from good real estate, good businesses, whatever you do that gets you that income. You got to learn to pay minimum taxes, and most importantly, you got to protect these assets. If you got a building, if you got a home, if you got a business, you got to protect these assets. Asset protection, I got a website, kmagb.com, the ultimate asset protection structure. I'm happy to tell you that last year, with the help of some great prominent people in the legal field, I was able to develop this incredible, wonderful way to protect your assets. I always felt that an asset protection program must have 4 things. It must be easy to set up, must be simple to use, easy to modify, and very simple to unwind. And that's what I want to talk about today. And a powerful structure for lawsuits, it is something you can use for pre- and post-nuptial agreements. It is wonderful when you do real estate loans and you have some challenges, including bankruptcies. And so the question you should ask yourself right now on the call is, are lawsuits more common today? I don't know, you tell me, look around. Can you get sued for practically anything? Do you even understand risk and where risk comes from? That's what I'm going to talk about here. And do you realize the damage awards right now are bigger than ever? And this trend will continue? The question everybody has is, what should I do about it? Now, I'm going to show you this little video. It went viral. It was on CNN. So I just want you to see, here is this little boy playing out here. And here, I'll have the commentator talk. Listen.
Check out this video. It's hard to watch. Surveillance videos of a family's home in Bakersfield, California. You can see that dog checking out what's going on with the neighbor. You see a kid on a bike, and for a few seconds, he heads around that car, decides to come upon that boy and attack the child, drag the child. The cat, the family's cat named Tara, comes to the rescue, chases the dog off, darting onto the screen, knocking that dog away, saving that little boy. Yes, I said cat. It's unbelievable. I'm glad to report that boy is okay.
Well, so you got the idea. Imagine if you're the owner of that dog. I mean, the kid is okay. If you are the owner of that dog, do you think you're going to get sued? Okay, let's put it in a different way. If you're the father or the mother of that child, are you going to just go to that neighbor and sue the heck out of them? You're going to want that dog put to sleep. And look, I love dogs. But this is crazy. Lawsuits can come from anything. This dog came out from the neighbor's yard. By the way, so you know, there was a lot of reports on this, and they started talking about lawsuits and how lawsuits are all over the place. You can see websites, how to sue your landlord in small claims court, how to sue a doctor, medicalmalpracticelaw.com, whocanisue.com. I mean, there are endless websites telling you who to go after and how to get them and how much in assets they have. So who is at risk? Are you a homeowner? Do you own a business? Do you invest? Do you flip properties? Do you hold assets? Do you get into partnerships? Are you a parent? Do you have teenagers? Do you have pets? Are you married? Are you considering bankruptcy? Everybody is at risk. And it comes from divorce, employees' actions, accidents that, you have a party at home, somebody falls, somebody comes to deliver something, they trip and fall, break their face, joint ownership pitfalls, teenagers driving, general partnerships, business transactions. If you have equity and you got money, guess what? You are a target. And the sad part, insurance companies are not going to cover you all the way. Many cases, I've had many students telling me horror stories where they were talked about that they were accused of contributory negligence, etc., etc. Insurance is not enough. And when people want to sue you and they go for punitive damages, it can ruin you. So how do you protect yourself? How do you protect yourself from lawsuits? Now, when you go to seminars, you hear a lot of people talking about separate your assets in different LLCs. Oh, you got 6 properties, put each one in a separate LLC. You got to set up 6 of them, $1,500 each. You're already at $9,500 or something like this. Use a land trust. The attorney is going to be the trustee. Well, guess what? Separate LLCs, you still have equity in one of the LLC. They're going to go after that equity of whatever's in that LLC. It's not the best setup. It costs a lot. It's too overwhelming for your spouse to understand what the heck you're doing. And if God forbid something happens to you, the spouse is left high and dry, having to go figure it out with attorneys. Use a land trust. You can put the beneficiary as the benefit. Nobody knows who the beneficiary is in a land trust, but in a court of law, and you can look at the court cases where the judge said, I want to know who's the beneficiary, and you got to let me know within 48 hours. Setting up anonymous Nevada corporations, look at court cases. The judges say, listen, I'm not going to play with this nominee stuff. If you don't tell me who are the shareholders right here, the court will take certain actions. I mean, people tell me, should I transfer assets to a irrevocable trust? Well, you just lost control of the asset. You can't undo that. Using offshore entities, don't go offshore. This is where a lot of problems happen. It raises the eyebrows of the IRS. Judges don't like it. They have repatriated assets. You can look at cases online. And people tell me, should I do nothing and hope the insurance is enough? No, there are cases where when you have something bad happening, the more unlikely for an event to happen, the more devastating it would be when it happens. Insurance is great. It's your second line of defense. Of course, first line of defense is act prudently. Second line of defense is have insurance, including not just all risk, but umbrella. But you got to know what else to do. And, people tell me, should I not own any assets? You got to own assets. You have to. There's no sense in not owning assets. How do you become wealthy if you don't have assets? Now, I have seen so many complicated structures. My gosh, I've seen attorneys talk about setting up a living trust and let it flow through to anonymous corporation in Nevada, then let the shareholders be a trust with the beneficiary being, joint ownership. We're going to put this in the name of the kids. We're going to put that. Family limited partnerships, complicating everybody's life. And at the end, people pay $30,000 and $40,000. And they don't even know how to function with all these structures. And they have to go back to the attorneys paying $200-300 an hour, maybe even $500 an hour to figure out what to do when they buy or sell a property. So the question is, how do you simplify protecting yourself inexpensively and build your fortress? So here's the ultimate asset protection. Owning an asset is not a liability. I want to be clear on this. Having equity in the asset is what makes you a target. You see, so here are the simple 6 steps. You got to show no equity. You got to do it legally. You got to use proper economic reasons. So if you go in front of a judge, it is clear why this was set up, and it's set up legally. You got to have all the proper legal documents to support your structure. Maintain the structure. You got to keep it up, and you got to stay in full control. You cannot rely on somebody else to do anything, and it's not that difficult, guys. Listen to me, 6 steps, and here it is in more details. How do you show no equity in your assets? Here it is in 6 bullet points. Number 1, tonight, I want you to figure out how much equity you have in all your assets, business, home, other investment properties. I don't care if you're in Texas, Florida, Homestead State, you still have liability. We set up for you a one LLC in Wyoming with a special operating agreement. Wyoming is very powerful for that. They have created LLCs. There are special cases for it. I can explain it later. We set up for you one LLC in Wyoming. Now, we capitalize it for more than all your equity. Let's say you have equity of $1 million. Let's say you have equity for $900,000. Let's just keep the numbers simple. We will strip your equity for $1 million. That means we're going to capitalize the Wyoming LLC by saying that it's going to have a capital to operate for $1 million. Since you don't have the cash, you will owe the LLC the capitalization amount of $1 million. And I have a team of attorneys that will draft promissory notes. That means you owe the LLC the capitalization amount of $1 million. We will have recorded liens against each of your assets, whether it's a trust deed or a mortgage note for real estate based on where your properties are located in the United States, or a UCC-1 filing for business. That means we even strip the equity. There will be no equity. It's going to show as a debt, as a lien, that you owe an LLC in Wyoming X amount of money. That means you have an asset, but you don't have any equity. The liens are recorded, and they strip the equity with legal justification and economic substance. Guys, if there is nothing to pursue, even charging orders will create a tax liability for the plaintiff. There is nothing for them to pursue. What creates a problem is if you are a target, if you have equity, if you have money, those that are interested in this, very simply, I want you to figure out how many assets you have, how much equity you have in everything, and there will be a 2-page form that you will need to fill out if you want to join us, if you want to structure this. My team of attorneys will get the Wyoming LLC set up for you within 72 hours. Operating agreement, 70 pages long. That's a business operating agreement. It has all the economic substance needed with the promissory notes for each property and each asset that you have. The liens will be prepared based on where the assets are located. We'll send you all the step-by-step instruction to operate. It's very simple, extremely powerful. You can be standing out there. You show everybody, this is what I own, this is what I have, and there is nothing for them. They can't do anything. They can't go after it. Invest in this structure once, and you keep it for a lifetime. The only other fee you have is the yearly renewal for the Wyoming LLC. It's one LLC, strips up all your equity in all your properties, and you guess what? You have that only to renew, which costs you less per year than what you pay for insurance on any of the properties. I'm not going to bore you with the details on how to get started. You can call the office. This entire structure costs less than $5,000 with the entire paperwork for the Wyoming LLC Articles of Organization, with the operating agreement almost 70 pages long, with an LLC operation manual that you will have. Everything is done for you. Everything is maintained for you. You will have the certificate of ownership if you want to sell the property, and there is the lien that is owed to your LLC. You show it to the title company. They remove the lien. You want to borrow a credit line. You have the certificate of ownership. You're owing your own LLC, and the structure is airtight, extremely powerful to make it happen. I rushed through all this because I'm very excited, guys. I have with me tonight Honorable Roy Landers. He's an attorney, the State Bar of California. He's a judge. He served in Southern California for 10 years. He's an entrepreneur, an educator, and a man that I hold in high regards. I would like to introduce and have him talk about a little bit of his background. Honorable Roy Landers. Are you with me, Mr. Landers?
Yes, I am. How are you?
I am great. Thank you. Can you tell the listeners a little bit about your background in law and what you've done?
Sure. I've been practicing for a little bit over 35 years, and most of that has been in business structures, putting together LLCs and corporations, etc. I also have a master's in taxation law, so I'm very familiar with the IRS and all of the codes that one would have to comply with respect to putting together asset protection modalities, etc. And as you indicated, I served as a pro tem judge for 10 years in the Southern California area, San Diego, as a judge where I heard mostly civil cases. And oftentimes I heard cases that are right on point with some of the things that you've already discussed tonight. So I'm very happy to be here and share with whomever's listening some information that perhaps if you've got questions or anything that I can do to assist. This is very exciting because one of the things that I've found out, and of course, Sharif, you know this, attorneys are extremely active in litigation throughout the country now. You don't have to do very
Yes,
much
sir.
to get sued at all. They advertise, they take contingency cases, they file class action lawsuits. It's really a mess out there now. In fact, I read
Mhm.
somewhere the other day that the average person is going to be sued a minimum of 5 times during his or her lifetime,
Oh
and
my God.
that's really an unfortunate situation. But that's what we're facing, and the only way that someone can really stop and make sure that they don't have any concern or any obligations that they can't handle is to really, really, really take a good, strong look at asset protection because you're right on point with the things that you discussed thus far.
Wow. Well, I remember you mentioned to me that how the legal system had changed through the years, that there were like some major fillers and guidelines from the American Bar Association. Can you tell us a little bit about how this changed and how it's more common now for people to sue, and why is this happening? Why is this the new trend?
Well, over the several years, the entire legal system has changed. It used to be that the bar associations, for instance, was very, very active, and they held attorneys to a very, very strict code of morals and ethics. And as you know, at some point in time, lawyers could not advertise. The reason why they didn't want them advertising is when you
Mm.
start to advertise, you have the ability to puff, to add a lot of stuff that may or may not be true. You take certain liberties that you shouldn't take to get people excited to sue when maybe there's not even a lawsuit. And that's why we have so many frivolous lawsuits right now. But unfortunately, that law was changed, and now since about 1978, I think the case was Bates versus Arizona. Over in Arizona, the Supreme Court says no, lawyers can now advertise. Well, guess what? When they started to advertise, all they did was create a lot of unnecessary lawsuits. Most of them unnecessary, as far as I'm concerned, in many of those cases. The other issue is that at one time, lawyers, in fact, could not take contingency cases. But now
Mm.
that rule has been overturned. Lawyers across the nation are taking contingency cases. And what does that really mean? That means that me as a lawyer, if I look at a case and I have the incentive to work it up, I can find a way to actually work up the case, file it, say I'll take a percentage, 10%, 20%, 30%, do all of the work,
Wow.
do whatever I necessarily have to do to create value in the lawsuit because it may have not have had any value in the first place. But the unfortunate thing is, I take it because I'm looking for a big hit. But in the meantime, there may be an innocent person on the other end. They're going to have to file the response. They're going to have to pay all of those law fees no matter what. Even if they win or lose, they've still lost because if they win, they still spend out 15, 20, 30, $40,000, God knows how much. But if the lawyer should
Yeah.
get a big hit and they find assets, then they're going to get 30%. So there's the incentive right there. So it's just it's a big quagmire now.
Wow. It's amazing because you can get a CPA to work on contingencies. That would be that's not allowed. But for an
No,
attorney, they can do it. That's interesting.
that's right. That's right. And not only can the attorneys do it from a contingency standpoint, that opens up all of the ability for the attorney to go in and take a look see, take a magnifying glass and look at everything the person has. What assets do they have? When did you last go to this place? What did you do? And they don't even have a case yet, but they'll look at everything because they're allowed to do it now. They'll be able to go and look at it and actually possibly find something. Well, guess what?
Mm.
If someone has properly put asset protection modality into place, does nothing to find, and if they do find it, you're judgment proof, at least as far as the lawyer can see from public records.
Yes. Wow. Wow. So what really drives the system then is one simple word: money.
Oh, absolutely. There's no question about it. Money. And if you're shown to not have any money, or it appears that you have no money, then guess what? The lawyer's incentive disappears. They're not going to take a contingency and spend money to roll the dice to look and find something, and then when they don't find it, they're going to stop. Why? Because they don't see anything there. So there's no nut to crack, so to speak, and find whatever goal that they're looking for.
So this is great. So in your opinion, what do you think of the structure that we have talked about? I know you saw me present this in San Diego last year, and that's when I realized you liked it. You stood up and you told me this is phenomenal. But what's, in your opinion, and you've seen a lot of cases and you've studied the law, 35 years practicing, what's your point of view, this structure versus other structures?
I think this is an excellent structure, and basically what you're really talking about is eliminating any equity that someone might have, and you've streamlined it, because I heard you say a moment ago that if you go to a typical attorney who does asset protection, estate planning, etc., you're not going to get out of there for less than $15,000-$20,000 if you've got any significant means whatsoever. But if you go to Wyoming, for instance, and by the way, I've done several Wyoming incorporations and LLCs myself. That's what I advise people to do. So it's sort of coincidental that you're doing that. And I think that's one of the best ways to do it. Is streamlined. It's extremely powerful. They have some special rules that protects the members of LLCs, the directors and et cetera of the corporation. So I think this is extremely a great product. And more importantly, if I think I heard you say you can get it for less than $5,000, that's a great deal. That's an absolutely superb deal. And I would just suggest that anyone who's seriously thinking about ironclad protecting themselves, that's a bargain. That is great.
Well, I asked Ashley if anybody sends questions to notify us. So, Ashley, if you get any questions, just go ahead and kind of interrupt any time and tell me if you have questions. Ashley, can you hear us? Sometimes she mutes herself, takes her a moment to come back.
Okay.
Can you hear me?
I have a couple questions. Can you hear me?
Yes, we can.
About 5 minutes ago, we did have somebody that was asking for a little bit more information. They are considering bankruptcy, and they were just wondering how this structure can protect them and exactly what it is protecting them from.
Okay, I will try my best to answer, and then honorable lenders will correct me if I make a mistake. There is no 100% rule for bankruptcy protection, et cetera, but I think the best way is if the structure has been implemented for at least 2 years, and they had the LLC, the liens payable to the LLC, and they make at least one payment a year the way we structure the promissory notes, and they actually make the payment, and they show that it's up and running for at least 2 to 3 years now. Then on the third year, when they file for bankruptcy, they can claim that as a debt and show exactly how it was structured. Am I correct in that answer, Roy?
Yes. The only thing that would unravel that is if the bankruptcy trustee was to look into it and it was determined that there was some fraud in the placement of the asset protection plan in the first place. It could unravel. The new rules came out in 2005. And they look at those very, very intently. However, you can avoid any possibility of fraud by simply making sure that you do it now rather than later, because if there is a claim that is either looming, about to be filed, or if a claim has been filed and you do the asset protection, then that would be subject to being a fraudulent transaction. It could be set aside. So the bankruptcy court may not accept that. But otherwise, you're absolutely correct.
Got it. So timing is very important. So what you're saying is anybody, actually it goes not just for bankruptcy, but also lawsuits. So setting up, you as a judge looking at something like this, setting up the asset protection before the problem happens, the lawsuits, the dog biting, the neighbor's hand, the people. So having that set up beforehand is more important than anything.
Oh, absolutely. That's why I would encourage anyone who's considering it, do it now. The reason being is if you wait until it happens or you're aware of a claim and then you should put one of these in action, and you get some lawyer who starts to look at it and find out, well, gee whiz, this is mighty close to the time period that this happened. It could be deemed a fraudulent transfer of assets that you're trying to hide the assets, and a civil court of law could set it aside, and even the bankruptcy trustee could challenge it, and the bankruptcy judge might throw it out. But if it's a concerted, clearly good faith effort that has been done prior to that, it's usually rock solid.
Okay, wonderful. Very, very good. Good to know. Ashley, other questions?
Yes, there's a couple more. We have a investor in New York, and he's saying that he's always been told that each of his rental properties should not be placed in his name. How would that be unraveled? And could all of his 7 properties be placed under this one structure?
Okay, I will again attempt to answer. The fact that he has properties in his name is not the big issue. If he has them in his name, it's fine. If he has them in an LLC, it's fine. The key thing that we're stressing here is the fact that whether the asset has any equity. So why transfer the asset? Why transfer to an LLC and run the risk of having a due on sale clause with the loan, the bank calling? Why do the transfer it and have the tax assessor's office calling him to reassess the asset and maybe be doing some taxes? Why do all that when you can just strip the equity, and when somebody sues you, say, I'm the guy, I'm right here, I got the properties, but then there is no equity because you set it up before a lawsuit happens and you're actually maintaining the structure, you're making the payment as agreed to your LLC, one payment a year, etc., like the way we structure it. Roy, any additional comments?
Yeah. Just I think you hit it right on the head, because the point of it is to the public records. When a lawyer takes a case, the first thing that they normally do is do a complete record search to see what is the ownership, even with the Secretary of State, to see if there's any personal assets that has any equity in it. But if on the records it shows that the home, the mortgage, the car, or whatever value there may be that might be shown in the public record, if it's completely mortgaged up or if it's leaned up to the point where there is no money at all, that's a great disincentive for a lawyer to just kind of go away. And the other thing too is, even if assuming for the moment that some lawyer then went ahead and got a judgment, if it's put together correctly, the asset protection, because it's not in the individual's name, that still would be protected. So the bankruptcy court would still wipe out the personal debt that or judgment that the person has against them.
Mm-hmm. Great. Ashley, any other questions?
Next question. What happens when I buy or sell property? I am a flipper.
Okay, wonderful. So say you get a property for $200,000, you're going to fix it for, say, $100,000, and you're going to turn around and sell it for $400,000. When you get it for the $200,000, you need to contact us, and what we do is we file another lien against that one for $400,000. You see, for the future value. This way, if you're dealing with contractors, you're dealing with anything, if you're afraid of any liability, you've already stripped the future equity of it, since it's going to be done within a few months, and you turn around and resell the property. When you come to resell the property and you're at the close of escrow, and the title company comes over and says, well, we see that there is a lien to the Wyoming LLC. What's the payoff? You show them the certificate of ownership, and that's it. You have that right. You are the owner. You just tell them the payoff is zero. It's done, and then they remove it. So that's the way to do it. For flippers, people that buy and sell properties, it's very powerful. It is. I don't even know how people function without it. As a hedge fund manager, I'm flipping properties, from $6-7 million all the way to $12 million. I mean, this is crucial for us to protect the fund and how we grow.
Roy, do you want to add anything?
No, I don't think I have anything to add on that one.
All right, next question.
Okay.
How do you handle the addition of a new asset after the document has been established?
Okay, it's just a simple. They call our office, they just email us, and we just set up one more promissory note and one more lien, and that's just a small fee that we just send it back to them so they can send it and file it. Very simple.
Next question, why is a land trust not adequate?
Because the land trust, okay, so you have the grantor and you have the trustee and you have the beneficiary. So the beneficiary is nowhere on record. But if you look online for court cases, and anybody can Google this and verify it, and we have the judge on the phone, ex-judge here to tell us, the judge can always say, I want to know who the beneficiary is. So it doesn't protect you from anything. It just, the liability is there. If you have equity, they're going to come after you, and it doesn't help at all.
That's true. Go ahead. Yeah,
no,
that's true. The other thing with a land trust too is if you got the property in a land trust, it has a couple of distinct disadvantages. The person who is a beneficiary, that converts it to what is called a personal property interest as opposed to a real estate interest. So that's going to create a possible liability because now they can attach it as a personal, although the property, no, but your personal property interest, they can. So you would need to create another entity such as an LLC and title it to even cover that personal property interest in it. So here you go, as Sharif was just saying, you don't want to have all of these unnecessary entities. And you'd end up having to do the reconveyances. If you wanted to get a loan or if you wanted to do a 1031, you got to go through the reconveyances. It's just not the most appropriate tool to use.
Very good point. To your point, just recently one of the students was telling me that he set up a trust and he was having the hardest time getting the proper insurance, getting the credit line, getting all this. So it's the gentleman that called from New York or sent the question from New York, I have $50 million of commercial properties in my name and the equity is stripped. When I walk to the bank and get a credit line, it's one form that I sign. I get insurance very easy. I get better prices on the loans, lower interest, lower fees on the insurance. If I flip all this and put it right into a C Corp or LLC, I guarantee you I'll pay probably time and a half what I'm paying now, if I can get loans or credit lines on these. So, simple entities, simple structure. I know it's kind of esoteric and people just really, it blows their mind away. But truly, if you're already set up with an LLC, fine, wonderful. Let's just strip the equity to the LLC in Wyoming. If you set up in your own name, which most of the people I meet do it, fine, don't complicate your life. Strip the equity, you're in control. Your spouse will understand it's only one form, she or he will have the certificate of ownership, and you can function, you can operate. Wonderful. Continue. Any other questions, Ashley?
Next, yes, we sure do. They're very excited about this tonight. Do you have to put each asset in an LLC first before transferring it into the Wyoming LLC?
Not at all. Not at all. That's the beauty of this. This structure I'm talking about right here can be done in 72 hours. In 72 hours, because not only is the LLC set up and we prepare the documents and then you go and file them, you can have properties nationwide and it's just one LLC in Wyoming that's stripping the equity. We know how to draft the documents. We have the team of attorneys. Judge Landers looked at all this. He loves the structure. We know what we're doing, and I'm telling you right now, they don't have to transfer. They don't have to separate assets. I had this guy having 3 Subway stores, 6 properties, and he was set up with so many entities. He was paying just over $9,000 a year just in renewal fees to maintain the entity, and he was so confused. We cleaned up all this, put one entity, and the Wyoming LLC doesn't even have to register to do business in any of these states because it's merely owed the money. It's not engaged in any business in any of these states. Okay, any other questions, Ash?
Yes, in the example you just gave, the Wyoming LLC forgave a $400,000 debt. Who is responsible for claiming this debt forgiveness on their taxes?
Okay, there is no debt forgiveness. This is a capitalization, owing the money to capitalize an entity. So when you actually fix the property from 200 to 300 and then sell it, this is a tax neutral transaction because even when you make a payment to the LLC, let's say you made a payment once a year for $3,000 or $5,000, it's a deduction from you, income for the LLC. But the LLC is a flow-through entity to you. So what you have as a deduction, you have back as income, so it's tax neutral. Same for the debt. You see, you had the debt, you didn't make that, you didn't, it was created as capitalization and now you waived it. So it was capitalization, not an actual debt. It's not like somebody actually loaned you money and you're not paying it back, where it would be actual income and you'll be taxed on it. Am I correct, Roy, on these assessments?
Yes, I agree with that. I agree.
All right, next question. What do you do after you strip the equity, but then later you have more equity into the property? How do you transfer it yet again?
Okay. So the question is, okay, Sharif, I got a property worth $1 million. It's free and clear. Let's just take it as an example. If you strip the equity right now for $1.1 million, I think in a few years it's going to be worth maybe $1.15 million. Well, here is the beauty of what we do. When you assess the equity of all your properties and you fill out the form, you get on the call, we talk to you, and we look at where your properties are located, what's the equity, etc. We strip the equity slightly higher. So the promissory note is, let's say, on that $1 million property will be at $1.2 million. And then we set up the interest on the promissory note, let's say at 6%, interest-only payment with the balloon due in 30 years. Minimum payment required is one payment a year. So on $1 million, 6% is $60,000. One payment due is $5,000. You're making that $5,000 payment, which is 1 month payment, from yourself to the LLC, which is yours. Now, the remaining amount, which is $55,000, which is 11 months of $5,000 each, interest that you have not paid, become accrued to the principal. So now you owe $1 million at 6% interest. At the end of that year, somewhere during the year, you made one payment of $5,000, and now at the 13th month, you owe $1.055 million. And the following year, you owe $1.110 million, and so on. It becomes a negative amortization that actually eats up any increase in equity value, because we begin with slightly higher value and it keeps increasing, wiping out any future equity increase. That's the genius in this structure, that it's once set up, you have peace of mind.
That's an excellent point. And the only other caveat that I would add, as long as the amount of the loan is reasonable, and it would be, if you're talking about 1.2, you're talking about $1 million property, that's within the bounds of reasonableness. So that would not raise any red flags, I don't think, at all, from even from a fraudulent standpoint or IRS or anyone. The other point too is, I misunderstood. If I did, forgive me. I think the other individual said, "What are you going to do with the equity that you get out of the property earlier?" Well, it's not equity. It's really a loan. If you're making a loan on the property, there's no tax consequences. There's nothing to pay. It's a loan.
Okay, good. Very good.
Thank
you for clarifying that 20%. We go like 20, 25%, no more than that, to Mr. Lender's point. So if the property is $1 million, we don't want to strip the equity more than $1.2 million, $1.25 million or so. Good point. Ashley?
Okay, next question. Does this structure also protect paper assets, securities, and retirement accounts?
Okay, wonderful question. You see, the LLC in Wyoming, you will be able to set up a separate tax ID and an online bank account somewhere that you can bank with, or out-of-state bank account that you'll have a branch locally in your own state. That LLC should not be conducting business, because it's just there to protect your assets. You would be capitalizing it. You owe money to it. That LLC, we've had some investors that actually just transfer their money to it. If they have a lot of cash, they can set up their trading account in it. This way, because it's protected by Wyoming Act, actually the act is right here. I'll tell you the exact act. The act is 1729-503. That protects them against charging orders, etc. Then they're able to actually set up their own trading account or cash in that actual LLC account.
There was a point also about, I think Ashley asked about retirement funds. Did I hear that?
Yes.
Yes, correct.
Well, the retirement funds would be exempted from another aspect, so they really wouldn't have anything to do what Sharif just explained, because that would be exempted if it's a 401k or 403b or a Roth or an IRA. That comes under a different exception, so the asset would still be protected.
Very good.
Very good.
Actually, any
just
other
a couple
questions?
more questions. Yes. If you have to make annual loan payments, then why isn't it debt?
Because you see, it is debt, but it's debt to capitalize. It's debt to capitalize. In other words, there are different forms of promissory notes. There is a promise to perform. Let's say I'm going to do a job for somebody. So I promise to perform these duties, and they can record a lien against my house. I'm supposed to perform certain activities. So if I don't perform these activities, they can sue me, etc. Right? There is a debt where, like, I borrowed from Bank of America $500,000, so they record a lien. So that's the debt. They gave me the money. If I don't pay it back, I have received the money, didn't pay it back. So now the Bank of America is going to show a loss of $500,000, and I have to show gain, and I have to pay taxes on that amount, even though I couldn't pay. When it comes to capitalizing, and there is a lien, I'm capitalizing and I'm paying it, making a payment. Yes, it is a debt, but actually it's a debt to capitalize. So I can change the capitalization, I can increase it, decrease it, and all that is in the operating agreement that we draft. Roy, any additional points on that?
Well, yes, and again, what the courts would look at is it what we call legally sufficient consideration, and consideration does not have to be money, as you just indicated. It can also be for an obligation that we've created for ourselves, and that is equivalent to money. So someone says, "Well, I have provided you with X amount of equipment, or I performed these services, etc. You owe me, and I would like to have some collateral or something, so that I'm protected for that." So that, in effect, can become a legally sufficient debt. It can also be capitalized, just as you've indicated. So I wanted to try and make sure that that's cleared up.
Wonderful. Thank you for that addition. Very good point.
Next question. When you are ready to sell the asset, what is the process within the Wyoming LLC structure?
Okay, very simple. When you're ready to sell the asset, you just show the certificate of ownership to the title company, because they're going to see the debt recorded, and then they'll give you the forms to sign to release that lien. And if you're getting, let's say, if you're borrowing money against the property, or if you're selling the property, you will have the proper forms from the title company, either to subordinate the lien for another lien that you're getting a loan on the property, or you're going to just show the certificate of ownership so you have that lien removed so you can sell the property and give clear title. Very simple. You could do it. You can give to your spouse to just hand the certificate of ownership. You'll have all the paperwork and all the documents that we send you to do.
Any additions, Roy?
No, I concur.
Okay. Next question. Can you please reiterate how to protect the equity in a home while not transferring the home into an LLC?
Okay, wonderful. So I own my home. Let's say it's worth $1 million, and I have $500,000 debt to Chase Bank. So what happens is I have $500,000 equity sitting in the home. The home is in my name, or my wife and my name. So what I do is I set up the Wyoming LLC. I capitalize it for, let's say, $600,000. We create the promissory note. We create the lien, and the lien is recorded against the property for $600,000. So now, if somebody wants to sue me, I haven't transferred ownership. I haven't done anything. It's just still in Sharif Metawar's name and wife. And what happens is when an attorney says somebody wants to sue me, so they go to an attorney. The first step is an attorney is going to see if there is merit to the lawsuit. And then number two, they're going to see if I have an asset. Oh, they're going to see the home. Number three, they're going to look how much equity do I have in that home. They're going to see I owe Chase Manhattan Bank $500,000 and some other entity $600,000. They're going to say this guy's upside down. He owes $1.1 million. The property's around $1 million. What am I going to go after? That attorney most likely would discourage the plaintiff from suing or will ask for an hourly fee because there is nothing to go after. That attorney is going to ask the plaintiff, why don't we settle for Sharif Metawar's insurance? Because even if they, and correct me if I'm wrong, Roy, here, even if they win the lawsuit and there is a charging order, there is nothing to collect. This person, this plaintiff will end up with phantom income tax bill on what they gain.
That's absolutely correct.
So you see how simple? I didn't have to transfer ownership of the property. I did not have to complicate my life with many entities, and it didn't cost me a lot. I just set it up once, and I'm happy. As I pay off that first lien, the second lien increases a little bit, and I'm in control of it. And God forbid something happens to me, my wife is not confused. My wife is not trying to figure out LLCs and talking to attorneys. It is set up correctly, and it's something I can pass on. That LLC, I can pass on the certificate of ownership to my kids, etc.
And one last point, just to sum a little bit of that up on this issue, is if an attorney goes and they find that the property is mortgaged up to the hilt, liened up to the hilt, those are the kinds of attorneys who normally are looking to take a case for a contingency fee. If there's no money there, they're immediately discouraged. In the meantime, as Sharif just said, now they go back to the potential plaintiff and says, well, now you got to pay me $400, $500 an hour. That's going to be very discouraging because the person, first of all, is going to look and they're going to know immediately, geez, that's going to be $10,000, $15,000 right up front. It's just not worth it. So the whole point is that asset protection sends such a strong message that lawsuits are just never filed in the first place. And that's the whole point.
Wonderful. Wonderful. It's a lawsuit deterrent. I love it. Actually, any other questions or can we move on?
I'm so sorry, just two more. If you lower the debt association with if you lower the debt association with the capitalization of the Wyoming LLC, wouldn't you need to file an amended tax return?
If you lower the tax, no, okay, all these issues about the debt back and forth is resolved in the operating agreement, and we're in compliance with the operating agreement itself. So once somebody's structured and they have questions, I give a full year of any guidance they want, and we have the attorneys can answer any question. This is a tax neutral. Like I had somebody asking me the other day, they were setting up this, and they said, doesn't this affect my financial statement report that I'm going to present to the bank? He said, I had all this equity, all of a sudden I have all this debt. Yeah, but guess what? Under your assets, you also have an LLC that has all this debt coming to it as an asset, as equity. So it's a tax neutral, it's a financial statement neutral, and what you have created as I want to capitalize the entity for so much. No, I changed my mind for so much, and you have the leeway and the economic reasons to do it. And it's not only for asset protection, but there are actually 17 reasons that this LLC exists, and that's how we follow the law.
And the great point about that, too, is you're absolutely correct. It is neutral because even though now you might have an LLC involved, it's a flow-through entity. So it ends up being the same thing from a CPA standpoint once the taxes are filed.
Excellent.
Next question. Yes. So do you recommend to only have this equity structure and not to have use of an LLC or a land trust ever again? Just use this and strip the equity.
Look, I'm not recommending anything specific for anyone because I don't know any specific cases by anyone. I am just telling you, this is how I set up. I have 50 million of commercial properties. The hedge funds have over 50 million right now in assets. I have actually transacted real estate for over 30 years right now. I've worked with a billionaire, and I'm telling you, I have a judge on the call that have seen cases for 35 years. And you can complicate any structure you want, any transaction you want, or you can simplify it. So any other comments on that, Roy?
Yes, and I want to also put up front, and I think you did this even before. Whatever we're discussing here this evening should not be taken literally as any legal advice on any specific case because we don't have enough facts to even be able to do that. But the other issue is from the land trust standpoint, there are some limitations that pale with in contrast to the LLC that Sharif is explaining. And I'd be very, very careful with using a land trust to try and do any of the kinds of things that we're discussing tonight. However, and having said that, a land trust does have its place, but we have to look at each one of the factual situations. And I would just suggest that you have someone look at it, perhaps Sharif and some of his advisors. I think you would probably, hands down, prefer the LLC structure as opposed to the land trust.
Yes, a lot of people, to add to what you said, thank you. A lot of people say to me, oh, I'm using a land trust or an anonymous corporation, so nobody knows that I'm doing this transaction here or there. I mean, who are we fooling? Do you think the judge will not be able to tell you, hey, I know you live somewhere. Where is your home? Or are you going to just lie under oath and say, well, this is really not my home because I'm not the beneficiary? I mean, let's just be real. I look for a structure. I do trainings and seminars. I stand in front of people. They come to my properties in California. They come to the properties in Puerto Rico. And I like to be open and show people what I have. I'm not afraid to talk about money and wealth, etc. It's part of life. So I look at cases where I say, what if I get sued? They know what I have. I am not hiding. I'm not lying. I'm telling the truth. And I'm structured in a way that I'm following the system to my advantage. Instead of getting bamboozled by the system and those ambulance chasers, I'm instead having, like Mr. Lender said, having a lawsuit deterrent structure where even if they insist on suing me, they will get nothing other than a tax bill because they will have phantom income because they can collect on the judgment and they will actually end up with a tax bill. So any plaintiff that wants to sue me will come to their senses and try to settle with my insurance or actually just drop the lawsuit altogether. So, good. So Ashley, I would like to move forward. Do you have any other questions or I move forward?
Well, we have at least 8 more questions coming, questions are rolling in so quickly. So I'll let you and, Roy make a decision.
Wait a minute. Judge Lenders, do you mind taking more questions? Is that okay with you?
No, I'm fine. Not a problem. I'll be here as long as you need me.
Let's have fun with it. Let's roll.
All right. Next question. I lost my only real estate properties to short sale due to the recent bubble fiasco, and now my residence is upside down. Yet I got only $800, and I am struggling to get a reasonable modification. I know I have a right to something. Can you please help me? This seems to be a question we can answer separately. Do you think, Sharif?
Well,
I can. If you want me to, I can address that.
Yes, please, Roy.
Well, as I understand it, did they have a loan modification before?
Yes, they did.
Okay, so they've had one loan modification, and they're upside down again.
Yes.
Well, under the new rules, they're entitled to actually try and get another loan modification under the new National Settlement Act that was just put into play about 2 years ago. Depends upon who the lender is. They've all signed a signatory pact that they would still be under the requirement to go through an entire new package and go through the entire modality of looking to see if they would qualify for either HAMP, which is the Homeowners Affordable Home Program, or an alternative that the bank or servicing agency might have within their own offices. But they do have to go through that whole process, and then there's a whole process that they have to go through before they can even file for a foreclosure. So the best thing to do is to go to the U.S. government website or go to the bank's website, and that bank is required to have a link that will actually take you to the portal to actually start the process, and they have to give you what is called a single point of contact. No more of this every time you call and you've got 5 or 6 different people you're talking to, and one hand doesn't know what the other's doing. The law now requires they must have a single point of contact.
Wow, this is great information, Roy. Thank you so much for that.
Next question. Does this keep you out of probate when a spouse dies and you want the asset to be passed on to your family?
No, it's not a problem at all with the asset being passed on because it's still in your name and the LLC is yours. So you're just passing on the assets, and part of the assets are the LLC and the property and the business, etc. So not a problem there. Roy, any comments on that?
No, if it's titled in the LLC's name, it would never go into probate anyway.
Mm-hmm. Exactly.
It would be.
All right. Next question.
Go ahead.
Does the equity in the newly created Wyoming LLC not show up in an attorney's search of assets?
Well, even if here's the beauty. Wyoming has a Privacy Act whereby the certificate of ownership and all this does not show up. They will have to actually get a court order. My understanding is a subpoena or so to the resident agent of the LLC to divulge of who the owners are, etc. But what is important here is the Wyoming Act protects them. So whether they know or not, they cannot do anything to the actual assets of that LLC because of the Wyoming Act. Mr. Lenders, any
correct.
Comments on that?
No, that's absolutely correct.
Yes. So it's a double protection because they have the privacy, and then even if they discover who they are, they still can't do anything to the LLC, the structure, because it has the proper paperwork with the operating agreement that has been approved. This is the key thing, is in the paperwork, not just the location of the entities. Okay, more questions.
Can I cancel my living trust once I get this set up?
Yes, of course. I mean, you can cancel any other structure. I've had people cancel all these multiple LLCs. I've had people cancel convoluted structure with Nevada, et cetera. So yes, they can. If the question is can they? Yes, of course they can.
And to confirm, all properties will now be able to stay in my name.
Well, yes, of course. I have not changed ownership in my own properties, and people want to sue me, they won't go far. So why would I actually do 2 or 3 steps when I already own them in my name, and the banks know me, and it's easier to transact that way. So yes, it's in their direct name.
Next question, and then we are going to have to get to the rest of your presentation, only because we only have so much time on this webinar. So all the other questions, if you guys can just call them into the office tonight. We also have the questions here, and Sharif and Roy will be able to get to them. But I'd like to end on, I have 17 properties. Can they all go under this structure?
Of course. Unlimited. It's only one Wyoming LLC. Unlimited number of properties. We just do promissory notes and liens. That's the beauty of this, and you only have to maintain one LLC. Moreover, if your property is worth $10 million or it's worth $100,000, it's just one LLC that you're going to maintain. That's why I say once you're structured once, you have peace of mind forever. You can add properties. We just add one promissory note and lien. Once you sell a property, you just remove that, and the life continues, and it becomes easier, and you don't have complications. And, I'd like to say, Judge Lenders, I think we people are enjoying this so much, we got to do another call. What do you think?
I'm available, so whenever you would like me to join you, I'll be happy to do so.
You're a good man. I think we really should do a second call on this because, we've taken calls and questions for half an hour and they're still rolling in. So I will continue this, and then we'll schedule a second call with you for other questions, and we can keep growing with the students that want to grow with us. So let me thank you, Roy. Let me just move forward here a little bit.
Okay.
So additional key points I'd like to mention which actually kind of wrap up a lot of what we talked about. Your Wyoming LLC is fully protected against charging orders due to the Wyoming LLC Act 1729-503. Very powerful, awesome. Your Wyoming LLC has a properly worded operating agreement. That is the key thing, ladies and gentlemen, that gives it legal and business reasons to exist beyond asset protection. Number 3, the promissory notes have interest-only payment with a minimum of 1 payment from yourself to the LLC per year. By the way, if the property is already in an LLC, let's say in California or in New York or something like this, then we strip the equity for that LLC and you'll make the payment from that LLC in New York or California to the LLC in Wyoming. Okay. Other payments shall be accrued and added to the principal owed. This wipes out any future increase in value. You do not need to pay ongoing legal fees as you are in full control to subordinate the loan, write them off, cancel them, etc. when you borrow or sell the assets. Your Wyoming LLC will offer full privacy to owners and managers. Plaintiff's attorney has to get a court order, a subpoena to contact the registered agent for the name and address of the owners. Number 6, plaintiff's attorney will not, that means plaintiff's attorney is the person suing you, okay? They have an attorney. Plaintiff's attorney will not work on a lawsuit against you on a contingency basis, usually when you get the structure, because there is no equity to go after. So they much prefer to go hourly, as Mr. Landers explained. Plaintiff's attorney will most likely discourage his or her client from pursuing this lawsuit and will suggest to settle with the insurance. Litigants, as well as plaintiffs, there are other words for it, who end up pursuing the lawsuit against you anyway, will collect nothing if they win, since there is no equity and they cannot go after any of the assets. There is practically nothing. Litigants who will then pursue a charging order from the court will end up having an invoice from the IRS for amount of lawsuit awarded but not collected. This is based on Internal Revenue Code ruling 77-137 for what's called phantom income. By the way, you can pay phantom taxes. Phantom income, you got to pay real taxes, real dollars for it. And number 10, you can pass on the structure to your heirs and continue such protection for years to come, keeping you in full control with a simple expense of the negligible yearly renewal fees for the Wyoming LLC. Any other words of wisdom on that, Mr. Landers?
No, I think you've covered it quite succinctly there. I kind of like the way you floated there, and I'm okay.
Thank you, sir. Well, the end goal is financial peace of mind. That's what I hope you understand. You want to get some steady and reliable income, pay minimum taxes, protect your assets, and continue focusing on your health and your relationships. Makes life a lot easier, keeps the game going, and once you have peace of mind, you are happy. Now, I often get the question at the end, people call the office and say, how did this Sharif Medawar, who was a hotel manager, become a master of deciphering the tax codes and asset protection structures? Well, I was lucky enough in the early 80s to work for a billionaire in the name of Edmond Bessari. He is his chateau in France in the Loire Valley. He has properties around the world. This chateau in particular, I was there just a year ago, and I'm going back in September of this year. Very exciting. Forbes magazine last year, in April 24th of last year, wrote an article about this particular residence he has that's worth $100 million. You can Google it. He is Edmond Bessari in the 80s with Ronald Reagan. Mr. Bessari lives in southern France now. He goes to United States every now and then. And he, is in his early 80s. So very successful man, brilliant man. I learned so much from him. And I learned the shortcuts. I learned the proper ways to do things. I knew that, once you work with a mentor and once you find a way and you hang on to this and you grow it, there is nothing like success. Those that want to do this, I invite you to call me right now. Call the office, 407-608-5448. If you still have some questions, let's get these questions. Let's get them because we can then be prepared for the next webinar we do. This is the ultimate asset protection structure. I'm telling you, I've had different attorneys go on conference calls, debated with me, and the conclusion, the consensus were, this is it. This is the best structure we have today. There are court cases after court cases supporting it if it's done correctly, provided, of course, you set up before any problem happens, provided you have the complete operating agreement with clear business purpose, provided the liens are filed correctly and the proper wording in full compliance with the specific state lending laws. Otherwise, the judge could dismantle the structure. I tell you that if you do not make the payments to your LLC, that structure is useless. So it's pretty simple. 4 simple things you got to do. 3 of them I do, the rest you do once a year, and you'll have something airtight and extremely powerful. We have developed something very simple called your risk level calculator. Call the office, 407-608-5448. You're going to fill out something. It's pretty simple, and then it's going to tell you, what risk level you are in. Okay? You want to set up this. Of course, when you call the office, say, I'm ready to set up. They will give you the 2 forms you can fill out right now. It's $5,000. You're up and running. 72 hours from now, you have peace of mind for life. So that whole idea is to teach you how to have full asset protection in a simple and powerful structure that keeps you in full control, so you can relax, you can enjoy life. And those that want to do this, I'd like to throw in a trained cat, like the cat you just saw, but I don't have any trained cats. So we're going to say, suffice it to say, check your risk level right now. Call the office, 407-608-5448, and let's make it happen for you. Email us, info@cmri.com. Put your phone number. Drop in a couple lines, your questions or whatever. I want to finish by thanking Roy Lenders for your time, for your energy. You're a true friend. And we're going to do another call. And I'm going to ask you to help me when we do the tax structure in the future. Is that okay, Roy?
That'll be fine. I'll be happy to join you.
Thank you so much. I really appreciate it. And I hope to see you all again soon. Thank you all. Good night.
Okay. Good night.
Thank you. Bye-bye.